So I've just been down to Slough delivering some training to a firm down there. We're talking all things reconstructions, and one of the topics was company purchase of own shares and multi-completion buyback specifically. So I thought that'd be a good topic for the next Technical Tuesday. The issue is that HMRC changed their view, or at least they came up with a legal opinion and updated their manuals to say that when you're doing a multi-completion buyback, effectively you need to drop below 30%. So when you're doing a company purchase of own shares, if you want capital treatment, you need to have a trading company, UK resident, hold the shares for 5 years, reduce your interest by 25% minimum each time, and you need to cease to be connected to the company, which is a 30% limit. And previously, the mechanism for doing a multi-completion buyback was to remove beneficial ownership, whereas now HMRC say for the purposes of that connection test, you need to lose legal ownership as well. So what that means is multi-completion buybacks are still possible, but on your first tranche, you need to drop straight below 30%, which could mean if you're doing multi-completion and you have to sell potentially a significant stake up front, then obviously the company needs enough cash to pay for that. And I always try to hammer home when we're talking company buybacks of shares, whether it's to other advisors or whether it's to clients, they seem simple on the surface, but they are one of the most common mechanisms that go wrong in my experience. And when they go wrong, they go horribly wrong. So if you get the legal paperwork wrong on a company buyback of own shares, it means that the previous shareholder legally still owns those shares, so potentially they've still got a claim on any future sales proceeds, and potentially they should be due dividends throughout the period that you thought you had bought the shares back and they had no rights. Potentially they still are owed dividends as well. So it's a really horrible piece of legislation really for the Companies Act, and something every client should get good quality advice, including a solicitor to help enact the buyback. And the Companies Act specifically says that to do a buyback, it has to be paid for in cash. So you can't buy back the shares and then pay it over a period of time with deferred consideration, which is where this multi-completion mechanism comes in. But the change that HMRC made probably a couple of years ago now says that for the connection test, for your 30% limit, you have to drop below that, and you need to sell the legal ownership to drop below that in order for it to work. So that came up today in today's training, and I thought it'd be worth reiterating that again because of the amount of times I see those go wrong.